And I suggest to you that you well knew all along that is exactly what the process was going to be.
No, that's not correct either.
One perspective on it is that it's because you're always looking the other way.
I wish I had scrutinised further. I wish I had asked more questions, but I didn't.
All the higher levels that I've sat and I've listened to through this, who can't remember, can't recall, can't recollect, couldn't put your mind to it, I can't forget.
This is a summary of Week 7 of the Royal Commission into Robodebt. If you haven't seen the previous episodes, then it's best you start from the beginning. I'll link to Week 1 in the description. The Royal Commission publishes these hearings on their website, and Week 7 had about 36 hours of footage. I've cut that down so that you can still hear the key evidence. So this is Week 7. We're going to hear from a lot of witnesses, including some that are returning for more questioning. There'll be plenty of government officials, but also the people who fought back and ended Robodebt. But first, we'll hear from Jennifer Miller, who lost her son to the scheme.
Ms Miller, can you tell the Commission your full name, please?
Jennifer Joy Miller.
You are the mother of 2 boys, Ms Miller?
Yes.
And Reece was the younger of those 2?
Yes.
He passed away on the 26th of January 2017.
Yes, that's right.
You came to learn that Reece received letters alleging debts in late 2016.
Mm-hmm. Yes.
And if we jump forward a number of years to 2020 and 2021, did you come to learn that monies recovered from Reece by the Department of Human Services prior to his death were refunded to him?
Yes, that's right. And
the debts that were alleged against him in late 2016 and continuing in January 2017 were zeroed, to use the term, which is...
Yes, that's right.
Thank you.
The government was chasing Reece for fake debts totalling $17,000. His mother was seeking the truth for years and got nowhere.
The attempts that you made to obtain information from various people, how successful were you, broadly speaking?
I had absolutely no success whatsoever.
Over what period of time?
Over the 6 years.
She got nothing of substance from the Department of Human Services or the Minister, Alan Tudge, the Commonwealth Ombudsman, the Office of the Australian Information Commissioner, the Coroner, or anyone else involved. In fact, the government did all they could to shut down her inquiries, and that's because what happened to Reece was completely inconsistent with their narrative.
No, I do not accept people have died over Robodebt.
But the department was happy to give out Reece's personal information to journalists. In early 2017, the Saturday paper ran a story about Reece and linked his death to Robodebt. The department panicked and tried to change the narrative by providing a bunch of his personal information and insisted that his case had nothing to do with Robodebt. They said it was part of a manual process.
And this was the department's request that the journalists publish a corrected story, as the department did not think it accurately represented the department's processes. See that?
Yes.
Information which related to Reece is contained on the next page of this email, 3811, and over to 3812. Where the department provided a very extensive account of the response to the story which had been published that day.
Yes, yes.
Mr Gregory, am I right in thinking that the only reason it wasn't an online compliance intervention is that he was part of the pilot and they hadn't got on to OCR at the stage the original debts were raised against him?
Yes, that's correct.
So it wasn't compassion, it was just that they hadn't got to unleashing the full scheme yet?
That's correct.
It's been very difficult to obviously keep persisting with trying to gain the truth. And of course, through now the Royal Commission, I have been able to obtain the truth. And I'm truly, truly forever grateful to everyone who has supported me throughout this whole time. I find it extraordinary the lengths they have been to try and get me to stop being so persistent. Once I saw all the information that we have, it was both heartbreaking, but also vindicating, seeing that we've been able to get the truth out for Reece.
After all the years of the government saying that what happened to Reece had nothing to do with Robodebt, the truth came out. His debt was part of Robodebt. These two witnesses were lead applicants in the Robodebt class action lawsuit.
If I start with you first, Ms. Pragodic, can you tell the Commission your full name?
My full name is Catherine Ann Pragodic.
And your occupation?
My occupation is a secondary teacher, maths and science.
Right. Ms. Button, your full name, please.
Felicity Teagan Button, and
Yes.
my occupation is a registered nurse manager.
That case resulted in a settlement of over $1.7 billion for hundreds of thousands of Australians. The settlement was basically a refund of unlawfully collected debt payments and some nominal interest. Hearing these witnesses talk about their experience, it's no wonder they agreed to be part of the case.
In 2017, my daughter had just turned 1 and she was extremely sick. So I took her to the doctors. Turned out it was an upper respiratory infection. And I went to go pay for the doctor's appointment and my card declined. And I checked my banking app on my phone and $11,500 was overdrawn in my account at the doctor's office. So that's how I found out that my payment plan had been stopped. And it turns out it had been stopped a few months beforehand, but no one notified me, nor by telephone, email, letters or anything. And I called Centrelink to ask why they had taken so much money out of my account, to which they responded, it's not in our hands, it's with a debt collector, you need to call them. They didn't tell me which debt collector, they didn't give me any contact numbers on how to contact this debt collector. So I called my bank to find out who had taken the money, and then I found out it was, I think, Dun & Bradstreet. So I Googled them and called them, and they said, sorry, but Centrelink has referred this to us and you owe this money. And then I said to the lady on the other end, well, maybe I should just drive my car off the road because I can't survive on no money. And I can't, sorry. And I can't.
Take your time.
And I can't pay for my daughter's medication or doctor's appointment. And then the lady on the other end was really nice to me and she said, that's okay, I'll get somebody to review this. And I stayed on the phone. I was on the phone to them for a few more minutes before another lady came on the phone and said, we'll return the money to you in the next 24 to 48 hours and set up a new payment plan. And so that's what happened, and then the money was returned to me in 48 hours and I was able to buy Ciara medication and the GP bulk billed me, thankfully.
These witnesses put themselves up against the Commonwealth in a high-stakes court case. In doing so, they took on a lot of stress and pressure.
How did you arrive at the position that the principal thing to do was to challenge the asserted debt?
I hoped that if my debt was proven to be incorrect, then Other debts that had been calculated this way would also be proven to be incorrect, and other people would get their money back. So that was what I thought was the principled thing to do, and I had the opportunity to do that, so I took that opportunity.
We then heard from the Chief of Staffs for both Maurice Payne and Scott Morrison, and they were taken through a bunch of administrative questions, and I didn't really get anything of value from them. The next witness, though, was a senior legal executive at the Department of Social Services, or DSS. If you remember from previous weeks, DSS had received draft advice from the law firm Clayton Utz, which said that Robodebt was unlawful. Instead of doing something with this, the advice was never finalised and disappeared. The questioning of this witness had a lot to do with that advice.
Can you tell the Commission your full name, please?
Paul Alexander, Richard Menzies-McVey.
And soon after you took up that role as a Deputy Chief Counsel in DSS Legal Services Branch in May 2019, you became aware that DSS had obtained some advice from Clayton Utz in respect of the debt recovery scheme implemented by DHS.
That's correct. It wasn't immediately after I became the Deputy Chief Counsel, but it was relatively short period.
A matter of weeks?
Yes.
Yes.
This witness tries to say that the Clayton Utz advice didn't actually say that Robodebt was unlawful. If this was true, the advice wouldn't have been significant. But the Commission takes him up on his assertion.
I don't have the advice in front of me, but my recall is that it said that the relevant provisions of the Social Security Act required actual income to be demonstrated, income earned, derived or received. Averaged income wasn't that. The Act did contemplate in some circumstances that averaging could be used, but this wasn't one.
That's right.
Which is often a very good statutory guide to the fact that it's not contemplated. And hence, the conclusion was that averaging was not, without more, permissible.
I think that's correct, Commissioner.
But you say they should have considered whether, even though it wasn't within the terms of the legislation in that sense, if you gave somebody the chance to say something about it, that would somehow make it permissible.
It would potentially allow a debt decision that was made by a delegate at Services Australia not unlawful, because the decision maker could have used those inferences to form a view that the person's income in that period was in fact the averaged income if the person didn't had the capacity to clarify that and didn't take that opportunity. And that's why the Solicitor General, some of the questions that were asked to the Solicitor General...
Well, never mind the Solicitor General, I just want to understand your inference. Your inference is, if you don't say any different, you must agree, therefore that must be your actual income. Is that it? Or I'm just trying to understand.
So, Commissioner, just clarify, I'm not saying that's my view of the law. I'm saying that I think was something that needed to be thought through by our lawyers to whether or not it did have that effect, so that the debt decision was no longer unlawful.
But you are a lawyer.
I am a lawyer.
I'm just trying to work out how you thought this through to think that there's some inference available if somebody didn't say different that would make averaging permissible under the Act.
It also turns out that there was a legal requirement for the Clayton Utz advice to be provided to the Department of Human Services, or DHS. If that had been done, it's likely to have forced the government to shut down Robodebt earlier.
Did you consider in May 2019 that this section was a direction to take reasonable steps to make the Clayton Utz advice available to Services Australia?
I did not turn my mind to that, Council, of complex...
Yes, you're not answering my question.
Sorry.
The question is, did you consider in May 2019 section 10.8 was a direction to take reasonable steps to provide the Clayton Utes advice to Services Australia?
I did not turn my mind to section 10.8 at the time.
Did you understand that section 10.8 applied to an advice of the type that had been provided by Clayton Utes?
I can see how it could apply. I didn't think that, I mean, I certainly didn't think in May or June that failing to provide it was a breach of the legal service directions. I didn't have that thought in my head.
Can you tell the Commission your full name, please?
Michael Nathan Johnson.
And your position and occupation?
I'm the Assistant Secretary of the Office of Legal Services Coordination in the Attorney General's Department.
The OLSC, or Office of Legal Services Coordination, is a part of the Attorney General's Department. Their role is to administer the legal services directions, which are basically obligations on how Commonwealth departments provide legal services. They're meant to be another safeguard which helps the government identify legal issues that arise. The problem is that when trying to figure out if something is a legal issue in the first place, it seems the OLSC just accepts what the government departments tell them. The previous witness, who was at DSS, as well as the DHS Chief Legal Counsel Annette Mussolino, were telling OLSC that the issues around Robodebt did not meet the definition of a significant legal issue, and so didn't need to be reported.
So was it the case that the department had only to say there is no legal issue, we're on sound legal ground, and you would fold up your tent and go away?
Not at all, Commissioner.
What did they do here that was special?
I understand the agency was genuinely believed there was no legal issue and conveyed that.
So if they sounded sincere, that would do the trick?
Generally, yes.
But look, Mr Johnson, DHS ran a program which they'd been warned at the outset, because it involved averaging as a default position, would not conform with the Social Security Act. They'd been warned about that at the beginning. They went ahead and did it anyway. The Ombudsman was easily deflected. You were easily deflected. What's it say about our checks and balances? Do you not see that as a concern? And when I say you, you understand, I mean the office, not you personally.
Yes. I mean, I think a retrospective review of what happened here can only reach one conclusion, and that's probably that the system didn't work.
But it didn't work at such a lot of different points which might have picked it up. And if you were always going to say, well, as long as the department says, with a note of truth in their voice, that there is nothing wrong with this, there's no legal issue, then that's it for us. We leave immediately.
Again, Commissioner, I'll go to the point that that's not the totality of the information that would have formed my predecessor's views.
The failure to report a significant legal issue to the OLSC is a breach of the legal services directions, for which sanctions apply.
Well, let's turn to sanctions, because the failure to raise the significant legal issue in January 2017 by Ms Mussolino or Ms Campbell led to many years with many consequences, not just financial, to the Commonwealth Government. What do you know about the sanctions which have been imposed by any of the Attorney Generals who have considered the question of what seems to be obvious non-compliance with the legal services direction?
Sorry, which non-compliance? The failure to report a significant issue?
Yes.
First of all, no sanctions have been imposed to my knowledge, Council.
Even for this matter?
That's correct.
Can you explain that?
I would query whether what occurred amounted to non-compliance with the directions in the moment. I've agreed with you that in retrospect, on all the knowledge that's at least available to me in this folder, I consider it correct that the matter was a significant legal issue and should have been reported. Whether that was subjectively known to the people involved such that it was truly non-compliance, or simply based on the information they had, it was a correct assessment, I don't know the answer to.
Obviously, that requires an investigation.
Correct.
In order to ascertain that. What's your understanding of the process by which an investigation which permits a conclusion about non-compliance with the legal services directions is commenced?
The purpose isn't to find out non-compliance and punish agencies.
I thought you referred to the element of sanctions earlier in your evidence.
Certainly, Counsel, and that is a statutory power that is given to the Attorney-General.
Yes.
But not to OLSC.
And given your long experience with the Attorney-General's office and with OLSC, how does the Attorney reach a point where a decision is made to impose sanctions for non-reporting of what is obviously a significant legal issue with such great consequences to the Commonwealth and the Australian public?
So as I've mentioned in my time, there has been no instance of a sanction being imposed for any non-compliance with the legal services directions.
It's uncharted territory, even in a case of this magnitude.
Yes.
They're not very alarming sanctions, are they?
I have no further questions. Thank you.
Thank you.
After all that, I'm not sure what the point of this agency actually is. Throughout the Royal Commission, we've heard a lot from executives and ministers. But let's now hear from a current compliance officer, Jeannie-Marie Blake, who was involved with Robodebt.
Now, you're a current employee of the Department of Human Services.
Yes, I am.
And you started working at DHS in about 2000?
Yes, I did.
You started as a compliance officer in about 2007?
That's correct.
And that's your current role?
Yes.
Ms Blake, I'm going to take you now to what I understand to be your first encounter with the Robodebt scheme. And that was through the pilot program, wasn't it?
Yes, it was.
In paragraph 14, you refer to attending an initial meeting where the pilot program was explained to you.
Yes, that's correct.
And you were called to that meeting along with the other compliance officers in Mornington?
Yes, the entire team was there, the team leader.
Am I right in understanding that your area manager said that this new way of doing business would involve increased use of automation?
Yes, that's correct.
And that it would involve averaging income data provided by the ATO over financial periods, which were usually entire financial years?
Yes, that's correct.
And that during the course of that initial meeting, you were shown some of the letters that you'd be using?
And the interface that they would see online as well.
Ms Blake, would I be right in saying then that the difficulty of using averaging over financial year periods was obvious to you?
Absolutely. You knew it was going to be inaccurate.
And am I right in thinking that averaging had on occasion been used in the past in your role?
I had never used it myself. And like I said, I've worked with some really experienced staff. I think they had used it as a last resort within the team. It certainly was never as a first resort. And to my knowledge, that there would be some sort of discussion with the customer before that would happen. And it wasn't something that happened often. I would say rarely would be a better explanation of where that was used. Rarely. And in my own instance, there was never a case where I decided that it would be best to average income.
And is that because you exercised your judgment based on the evidence available and you didn't see a circumstance where it would be appropriate to average?
That's right. And in fact, if I couldn't find the employer because the employer had been, closed down, or the customer didn't have any other way of providing information, I would usually just take it out of the data match and say it's inconclusive and there's not enough evidence to base an overpayment on, and I'd remove it.
Ms Blake, rather, am I right in saying that there are several concerns which are articulated in paragraph 19 broadly that were obvious to you at the stage of that meeting?
Absolutely obvious to me, and I think to everyone in my team.
And were those concerns raised in the course of that initial meeting?
Yes.
Your memory is that the pilot program started in about 2015?
Late 2015, I think.
And that it ran for a few months, give or take?
That's correct.
And am I right in saying that your view was there was a significant shift in the day-to-day work that you did?
It was completely foreign to what we had normally done.
And how did you feel about that shift in your role?
It felt unethical. The mental stress and pressure that was placed on staff for this policy. We were conduits to an arbitrary and unaccountable policy that allowed customers to give us their rightful anger and being upset about a process that wasn't fair, but that came back to us. Our managers did not care, did not want to hear about it, didn't want to know about it.
So am I right in saying that when you raised concerns, those concerns fell on deaf ears?
Yes.
I have a few final questions which I wanted to ask. The first one is why it was important for you to give evidence today.
Mornington was an office that worked at some level through every stage of this whole Robodebt debacle, and we were speaking about the incorrectness from the start till the end. And all the management, all the higher levels that I've sat and I've listened to through this, who can't remember, can't recall, can't recollect, couldn't put your mind to it, I can't forget. And I know there are many more staff just like me who can't forget what happened and what we were forced to deliver to customers.
Here's another senior lawyer in charge of the litigation team at DHS at the height of Robodebt.
Mr. Rosa, could you please state your full name?
Matthew Richard Wandsworth Rosa, R-O-S-E-R.
Thank you. Now, you were employed by DHS as a general counsel, DHS being the Department of Human Services, between 22 May 2017 and 15 November 2019?
I was.
Okay. Sorry, from 22nd of May 2017 until January 2019, you reported to Annette Mussolino?
Yes, as Chief Counsel, yes.
And then thereafter, Tim Ffrench?
Yes.
Thank you. Prior to holding this general counsel role in the Department of Human Services, were you a partner at Mills Oakley?
Yes, I was.
What area of law did you practice in?
General litigation, specifically Commonwealth focused.
Okay. And would that include litigation in the field of administrative law?
It would, yes.
Okay. And would you therefore have had familiarity with the principle of administrative law that administrative decisions are generally required to be based on evidence?
Yes.
And that administrative decision that's not based on evidence is potentially invalid?
As a general proposition, yes, yes.
Thank you. Mr. Rosa, do you recall attending a conference of the Australian Institute of Administrative Lawyers in July 2017?
I certainly recall attending. I'm afraid I don't recall the date, but I certainly recall the conference.
Right. Did you watch Mr. Hank's presentation?
Yes, I did.
All right. Didn't he make clear in that presentation that an aspect of the Robodebt scheme was that it calculated and raised debts based on income averaging?
Yes, yes he did.
Right. And didn't he make it clear that in his view that was unlawful?
Yes, he did.
So would you agree that at that stage it must have been apparent that the Commonwealth faced potentially some very serious legal exposure,
Yes,
including reputational risk.
yes.
And indeed, if his opinion were correct, that the Commonwealth was taking money from social security recipients that it wasn't entitled to on a massive scale.
If that opinion proved to be correct, then that would also naturally flow, yes.
Did you express any views about whether or not an independent legal advice should be obtained?
No.
Okay. Did it occur to you that would have been a prudent course to adopt?
No, I didn't think it was a prudent course to adopt at the time, no.
Why is that?
This had been a decision, and the department had been operating the scheme in its various forms. I think it was originally OCI, and it might have had some changes in name and changes in iterations for some period of time. And if a legal test case was presented, then that would surely be the time when advice was obtained.
This significant and credible question of legality having been raised, the general approach was, let's hunker down and hope they don't sue, or worry about it when they do sue?
No, I don't think that with respect, Commissioner, is a complete assessment. I think that there were certainly discussions about the issue. I wasn't privy to those discussions, but my understanding was that these matters had been considered and a decision had been made that there was an ability for the department to proceed with the scheme in its then current form.
Sounds pretty much like hunkering down and waiting till they sue, but because no steps were taken in response to this, were they?
Certainly not by me, Commissioner, no.
Or by anybody that you knew of, in terms of getting advice or exploring the issues raised?
Not that I was aware of in terms of getting advice, no.
All right, thank you.
Thank you, Commissioner. I just want to clarify your understanding of the position following Mr Hanks' lecture. Notwithstanding the significant and credible legal issue Mr Hanks raised, your understanding was because a decision had been made by government to proceed with this scheme using averaging, there was no point at that stage raising with people within the department the need to obtain independent legal advice.
Correct.
Okay. And is that understanding you obtained yourself, or is it something that you obtained after communication with others?
No, that was my personal view and approach.
Right.
This is ridiculous. In 2017, there was a clear warning that Robodebt was unlawful, and this warning was ignored. This witness didn't think it was necessary to get proper legal advice to confirm the government's position. Instead, he thought it'd be better to wait until there was a lawsuit, which in 2019 there finally was. The first test case, the Masterton case, was filed. Now the department had two options. Option 1 was to let the federal court consider the case and issue a ruling on the legality of Robodebt. Option 2 was to shut the case down and not let the federal court make a ruling. The way this would be done would be to recalculate the debt down to zero.
It says, we consider that option 2 is very likely to be the department's preferred approach.
Correct.
Option 2 being recalculate without averaging. You agree?
Yes. Yes, I agree.
As it is likely to end the federal court proceeding. The only scenario in which option 1 appears to us to be more attractive is if the department had a positive desire to have the federal court issue a ruling on the legality of the use of averaging and/or the OCI system. We do not understand this to be the case.
Correct.
Now, do you agree with me that Mr Ensby is expressing an understanding that the department did not have a positive desire to have the federal court issue a ruling on the legality of the use of averaging?
Through Ms Masterton's claim, yes, I agree.
And if the debt was reduced to zero, what would be the consequence of that?
If the debt was reduced to zero, there would certainly be an argument that there is no longer a matter in issue to be no longer a justiciable matter.
And we're of course lawyers here, Mr. Rosa, but there are people watching this that aren't. What are we referring to by not a justiciable matter?
No longer something in contest between the parties that the court need hear.
In other words, that a recalculation of a debt to zero might then mean that the court would not need to determine the proceedings that have been brought by Miss Masterton.
It might, yes.
So the department didn't want a court ruling and wanted to recalculate the debt down to zero. The problem was that Masterton was refusing to provide any further details to the department. So they decided to use a completely different process and rely on a statement that said that Masterton had declared her income correctly.
Do you see at the bottom of the email on the page, going over the top of the next page, there's an acknowledgement that what was proposed, that is to use the affidavit to recalculate the debt, was not the normal approach. And that doing so might set a precedent for future customer contact.
Yes, I can see that.
Notwithstanding those concerns, the view was formed that the debt could be recalculated using the affidavit material.
Yes, that's correct.
In circumstances where it was contrary to the normal approach and might set a precedent for future matters.
That's correct, yes.
So in Miss Masterton's case, the reasonable thing to do was to accept her word for it that she'd properly declared her income in the past. Well, she said to the best of her recollection she had. So that should be acted on.
Well, it's more, Commissioner, the reliance on the sworn evidence in the affidavit.
Oh, I see. So if all those people who had contacted Centrelink saying, but I declared my income properly, had just put in stat decs, they'd have been accepted.
That's unfortunately, Commissioner, that's not a question I can answer. That's a question for customer compliance and integrity. I don't know the
Mr. Rosa, you know that that the assertion, sworn or not, that income had been correctly declared wouldn't have stood an ice cube's chance in hell against the OCI program, which was designed to average income if there were no other evidence. And if all that the recipient had produced was an assertion, sworn or not, that they'd properly declared their income, there was no way that they wouldn't have had a debt raised.
Well, I assume that's the case, Commissioner, but I didn't work in that area, so I can't definitively say,
Right.
Commissioner.
Thank you.
See, the way this looks, Mr. Rosa, is that the department was proposing to act contrary to its normal approach and risk setting a precedent for future customer contact in order to make this litigation go away.
Yes, I understand that.
Do you accept that proposition, Mr. Rosa?
I accept the proposition that certainly is how it appears, yes.
This was important evidence. It showed that the government didn't want test cases against Robodebt to play out in court, and they were happy to apply totally different processes to recalculate debts down to zero so the case wouldn't be heard.
Yes, Mr. Scott.
Commissioner. Mr. Ffrench, could you please state your full name?
It's Timothy Lee Ffrench.
Is this right? You commenced employment with the Department of Human Services in 2012?
That is right, yes.
You left that department on the 15th of June 2020?
Yes.
Thank you. And would this be right? You occupied a variety of legal roles when you were employed in that department?
Yes.
One of those being Chief Counsel between the 24th of January 2019 and 14 June 2020?
That's right.
Okay.
This witness was the Chief Legal Counsel at DHS from 2019. He replaced Annette Mussolino.
Can you comment then on what the dynamics in the department were like in 2017?
It's a short question, but a big one. I think the dynamics in 2017 were not the kind, well, we're talking about culture, I think, culture and leadership. Those things at the time were not conducive to a proper examination of issues relating to this particular program, given that I think many people were determined to achieve a particular outcome for government. Once they'd reached that state of mind, I think that the inquiry, the honest inquiry into issues like the ones you're raising, was not something that that was fostered by that culture. I think it was, I feel, that sounds terrible, I realise that this is a significant occasion, I shouldn't say I feel, I believe that the culture and environment at that time prevented people from asking the questions that they should have asked because of fear that those questions would be seen as potentially impertinent, unnecessary, or that the people asking those questions may have been presented as being blockers to the achievement of particular objectives.
Were there any particular individuals that, on your observation, contributed to that culture that you just described?
Yes.
Who?
Melissa Golightly.
Okay, anyone else?
Well, to the extent that Ms Golightly's behaviour was enabled and fostered by another, it would be the Secretary.
Melissa Golightly was a Deputy Secretary at DHS and was a massive supporter of Robodebt. She died before the Royal Commission started. And the Secretary he's referring to was Catherine Campbell, the head of DHS, and later the head of DSS. Let's skip to 2019, when the Commonwealth Ombudsman was again looking into Robodebt. In responding to that draft report, this witness made assertions that Robodebt was lawful.
Now, the second bullet point in that email states this: the legality of procedures at the heart of the EIC system is not uncertain, nor does the department accept that EIC raises concerns about the legality of programs of automation. See that?
I do.
Those words, the legality of procedures at the heart of the EIC system is not uncertain. Do you accept those words are not true?
I accept that those words represented the department's position, but I also accept that those words are plainly not true. I regret clearing those words. The legality at the heart of the EIC system, in my view, was uncertain. This is a positional statement with respect to what the department was saying. If I had my time again, I think I would temper some of those words. I'd also make it very clear that what I was doing was describing the department's position.
Because what I suggest was being represented by the totality of these words in this email was that the department was confident in the legality of the program.
We referred to the draft report before where the Ombudsman noted that the department was strenuously refuting any suggestions otherwise. That was plainly the case for 2 years prior to this.
When, contrary to that representation, within the department, at least from your point of view, the department's position was manifestly weak.
I didn't say manifestly. I said that I didn't. Yes, I did believe that the department's position was weak.
The object that was sought to be achieved ultimately by the department was to persuade the Ombudsman to remove the section commenting on legality in the report, correct?
I understood that to be the objective.
And the department secured that objective?
The department did.
That is, that section commenting of legality was removed, wasn't it?
It was.
Later, when the Masterton test case was filed in the federal court, the government obtained prospects advice, which showed concerns on the legality of Robodebt. This witness says he went and raised this with the minister, who at the time was Stuart Robert.
When I went to see the minister, I took a copy of the prospects advice in Masterton and I spoke to it. And I raised with the minister the concerns that that advice raised about the lawfulness of the Robodebt scheme and the need for the Solicitor General's opinion.
What did he say in response?
I honestly can't recall. I think he accepted. I can't recall. There were... I think I have referred to statements the Minister made about an opinion just being an opinion. I'm not sure if it came out of this discussion or a later discussion. I think it might have been this discussion because prior to later discussions with the Minister about the legal challenges, I had drafted a minute to him where I tried to counter that perception that I saw that it's just an opinion until we get a judicial declaration from a court. An opinion's only an opinion. I believe it might have been this meeting where he said something like that.
After a second test case was launched, the Solicitor General confirmed to the government that Robodebt was unlawful. The Secretary of the Department, which at this point was Renee Leon, asked for advice on what she could do with the scheme.
And it says the settled legal position is now that reliance on apportioned ATO PAYG data alone does not provide a sound basis in law upon which to raise a social security debt. See that?
Yeah.
And then you say specifically you've asked how much flexibility you have or do not have and how and when you take further action.
Yes. Yes, I do. And throughout that document, I've said things along the lines of the prime consideration must be to minimise harm.
Yeah.
What I was giving to the Secretary here is information that was relevant to her determination as to what to do about this scheme. By this stage, it was plain something had to be done. You haven't referred yet to the minute that I gave to the Secretary where I outlined her obligations and her explicit legal risk. That was behind this document. What the Secretary was asking me here is, what flexibility do I have? And that to determine what to do, she had to take into account a large number of things. It wasn't for me to exclude anything. It was a matter for the Secretary of the Department to make that decision. And she did the next day.
The next day?
The next day.
What decision's that?
That was to suspend the scheme.
Okay.
We will hear from Renee Leon in a later video. A witness that returned to give more evidence was Serena Wilson, a former Deputy Secretary at the Department of Social Services. In her last appearance, covered in the Week 2 video, it became clear that she knew in 2017 that the scheme was unlawful, and yet failed to do anything to stop it. In this appearance, the Commission questions the witness on earlier periods where the proposal was still being developed. There are again references to Melissa Golightly, who was this witness's counterpart in DHS.
You communicated your strong opposition to Ms Golightly orally.
Yes.
And you are aware now at least that it was included in documents sent between the departments which Ms Golightly ultimately received.
Yes.
That is, there was no ambiguity in your position on the proposal that it should not proceed.
On the proposal as we understood it then, yes.
Yes. One of the points you make in this statement, and that paragraph can be recalled, is that you found your interactions with Ms Golightly to be not as you might have hoped. What do you mean when you make those references to her about how you found your dealings with her?
She was a very forceful character. She didn't enjoy being questioned and made that pretty clear. She was very confident in her own judgment.
After concerns were raised, Golightly made assurances that income averaging, which is the dodgy bit, won't be used, and this apparently put everyone at ease. But there was evidence that this witness had documents showing that income averaging would still be used.
Well, it says the ATO data would be used as the trusted source.
Yeah.
Yes. Which rather suggests it is the basis on which entitlement is calculated.
Reading it now, yes.
Yes. That is, the application of ATO data necessarily involves apportioning or averaging the PAYG information to fortnightly periods.
It's not that explicit.
No, but what else could it mean?
I don't know, and I can't put myself back in time to when I read this. Reading it now, knowing what I know now, it raises lots of questions for me, but at the time it didn't. And I can't explain that, but it didn't.
Yes, my question is really simple. The application of ATO data necessarily involves apportioning or averaging PAYG information to fortnightly periods. Would you agree?
No, not necessarily. It doesn't actually say that.
How would you ever use that data to calculate entitlement except by averaging its annual data?
It's generally annual data, I agree. It wasn't always annual data. Sometimes it was, there were periods evident in what the employers had provided to the ATO, as I understand.
Nobody ever gave a fortnightly breakup, did they, to DHS to work off?
Look, I don't know, Commissioner. I really don't know. I can't answer the question. I don't know.
This is basically the same document that DSS was telling DHS was problematic a year earlier, and this time it seems to have slid through.
And I think slipped through is the operative word, Commissioner. There was no deliberate ignoring of it.
Well, clearly not, because you corrected a spelling error.
Yeah, it slipped through, and I regret that it slipped through. And it would appear that it didn't just slip through me, but I cleared it, gave feedback on the document, and it slipped through.
And if you were hazy about what the application of ATO data to a customer record meant, to ask.
I wish I had.
Seem to be a lot of missed opportunities.
Yes, and that falls very heavily on me, Commissioner.
But one perspective on it is that it's because you're always looking the other way.
No, I reject that, Commissioner. I was very consumed with my own responsibilities. It was a DHS measure. I wish I had scrutinised further. I wish I had asked more questions, but I didn't.
We saw this next witness, Jason Ryman, also give evidence in the Week 2 video. He covered the early development of Robodebt, and it was a train wreck. You may remember that he was the one nominated for an Australia Day award. Anyway, he's back again for more. This time, questioning focused on proposal documents that went to Scott Morrison and Cabinet for approval. First, DHS prepared a brief for Morrison detailing the Robodebt process. In that draft brief, the proposal said that the scheme would use income averaging to calculate debts. DSS had come back to that draft with concerns and warned that the scheme would be unlawful if implemented. This witness claims he never saw those warnings.
Do you recall seeing this document in January 2015?
No.
Never saw it?
Never saw it.
Okay. That what this document is an extract from the draft brief to Minister Morrison in 2015 with DSS's comments on that brief. Do you agree with me that it is clear that DSS strongly advised against the proposal?
Yes.
And I just want to ask you about the second bullet point in that box. DSS Public Law Branch confirms that the suggested calculation method does not accord with Social Security legislation, which specifies that employment income is assessed fortnightly. Do you see that?
Yes, I do.
Now, are you aware that the DSS Public Law Branch was comprised of lawyers?
Yes.
And are you aware that what that bullet point is conveying is the effective legal advice that what was proposed was unlawful?
Here they're saying it doesn't accord with legislation.
Sorry?
It's clear they're saying it doesn't accord with legislation.
Which means it's unlawful.
The draft brief this witness apparently never saw was first sent to his boss, Scott Britton. Just a few hours later, this witness had drafted responses to the DSS concerns. Not sure how he was responding to the dot points in the brief without seeing the brief itself.
And then your email at the bottom of this chain is at 12:50 p.m. the same day.
Yes.
A matter of hours after Mr. Withnell's do not forward email.
Yes.
You see the top of the page is headed FW:DSS response dot points.
Yes.
And would you agree with me that in a general sense, what seems to be done in this document is an attempt to respond to the criticisms of the proposal in the document that we just looked at before?
I can't agree with that.
Why is that?
I was not responding to that document.
What document were you responding to?
My recollection, I was asked to provide some dot points for Scott Britton in relation to why we think we can do this.
Well, the top of the page has DSS response dot points.
Yes.
And we just looked at a document that sets out dot points outlining why DSS opposed the proposal.
Yes.
And it's a document that was forwarded to Mr. Britton from Mr. Withnell a matter of hours before this email.
Yes.
Can you think of any other document that you were responding to that day at that time?
I wasn't responding to that document.
What document were you responding to?
I wasn't responding to a document.
I see. So what led to this email?
I was requested by Scott to provide some dot points for DSS.
Right. And for what purpose did he disclose?
I don't recall exactly, but I think it was along the lines as to, can you prepare some dot points of why we think we can do this?
Right. So you were not aware at the time of this email of what you were providing the dot points for?
No.
Mr. Britton didn't tell you?
No.
He didn't show you that?
No.
Right. So you were just stabbing in the dark as to what to address?
It was, please provide, again, the dot points are fairly general and saying they go to why we think we can do this, why we think this is a doable thing.
Okay. Oh yeah, where did you get the words PAYG, clean up from?
I don't know.
See, those words were used in the document that we've been discussing, weren't they? That was how the proposal was described.
Yes, it's described that way in that document.
That suggests, rather, Mr. Ryman, that you did see the document.
No, I don't agree. The first time I saw the document was a couple of days ago.
The Commission is trying to say that if he did see the draft brief, then he would clearly know that there were strong concerns around income averaging. This is important because not long after, a new policy proposal document was being prepared for Cabinet to give Robodebt the go-ahead.
See that, Mr. Ryman? Do you recognise that as a draft new policy proposal?
Yes, I do.
The attachment to the email we just discussed?
Yes.
Do you agree with me that it clearly indicates that the proposal included a proposed assessment of social security entitlement based on averaging?
Yes.
Thank you.
The new policy proposal initially set out the fact that income averaging was a feature of Robodebt, but those references would soon be completely removed by this witness.
Well, my recollection of events is on the afternoon of the 27th. I made a number of updates to the MPP, the new policy proposal.
Updates after what happened?
After what happened?
Yeah, what were the what specifically happened that led you to making those updates to the NPP?
I don't recall specifically. They're not updates I would have made autonomously, so I would have been directed to make updates.
By whom?
Would have been either by Mr Withnell or Mr Britton.
Okay. Is this the revision to the NPP that you made on direction from either Scott Britton or Mark Withnell following that meeting?
Yes.
Okay. We can see in track changes the amendments.
Yes.
Do you see, first of all, the new words added? The new approach will not change how income is assessed or overpayments calculated.
Yes.
And the words acknowledging that averaging would be used in the process are deleted.
Yes.
And you understand that it's a situation where the reference to averaging is taken out after DSS has said it doesn't conform with the legislation, it's not lawful. So it looks very much as if it's been removed to deceive people into thinking it's not happening. Do you accept that much?
Yeah, I see your point, Commissioner.
Can you shed any light on that?
No, I can't. I certainly haven't done that to mislead anyone. I've been operating under instruction, is my belief, because every other version I'd had been part of back from 2014 through had included it.
All right.
We'll now hear from Scott Britton and Mark Withnell. There was a lot of returning witnesses this week, and Scott Britton was another one that we saw in week 2, and he was the immediate manager of the previous witness, Jason Ryman. The questioning focused again on the proposal documents and the concerns that had been raised very early on. We're again taken to the draft brief to Scott Morrison. This is that document Jason Ryman said he had never seen.
You accept that the sections in the square boxes are DSS's comments on the draft?
Yes.
And my point is that the language in the dot points clearly convey opposition to the proposal.
I think it definitely raises questions. Absolutely, yes.
All right. Well, in particular, if we call out the second bullet point in the square box on page 2, you see that bullet point contains these words: DSS Public Law Branch confirms that the suggested calculation method does not accord with Social Security legislation, which specifies that employment income is assessed fortnightly.
Yes.
You see that?
I do see that.
It's intuitively obvious, isn't it, that the DSS Public Law Branch would be comprised of lawyers?
Yes, that would be, reasonable to assume, yes.
When it says that the DSS Public Law Branch confirms that the calculation method doesn't accord with Social Security legislation, don't you read that as meaning our lawyers say this does not accord with the legislation?
I think as I read it now, Commissioner, absolutely it's clear. But at the time, I wish I could remember what the thinking was. The advice I was consistently given from our experts was there was no legal issue with what we were proposing. So that was the first point.
So by our experts, what are you referring to?
So experts within business integrity. So the people we relied on, people like Jason Ryman and his team that were developing NPP concepts, design, engaged with legals. The advice I was consistently given was there was never a concern raised around legality as it relates to what the initial concept was.
As the Commission then points out, Jason Ryman isn't a lawyer, and his expertise didn't extend to legal questions that were being raised by lawyers at DSS. This witness and his superiors were given clear warnings about Robodebt being unlawful, yet the proposal still ended up in a new policy proposal for Cabinet. This is that document where references to income averaging were removed.
And what's been deleted in the amendments are the words that appeared in the draft from the previous day. Those words which you agreed referred to an averaging approach.
Yes.
Now, do you have a recollection at all of the circumstances that led to this amendment?
No. I wish I did. Certainly not part of any conversation I had was, okay, we're going to exclude this so that it doesn't go forward. Like that wasn't part of anything that I was having a conversation about.
It certainly got taken out, and you can't explain.
No,
this.
I agree, and I can't explain why, Commissioner, you're right.
Mr. Ryman has given evidence, and the transcript reference for my friend is page 3582, line 15, that it was taken out either at the direction of yourself or Mr. Withnell. Can you comment on that, Mr. Britton?
I have no recollection of that. I honestly don't know how to respond to that, because it's particularly based on what you were suggesting, Commissioner. I mean, it was, yeah, I have no direct recollection of a conversation where I explicitly said remove that for a particular reason.
Okay, well, what about a conversation where you said remove that?
I can't recall that either. I wish I could, but I genuinely can't recall most of, as it related to the conversations with DSS at that time.
And the omission of those two matters, that is that there was a methodology of averaging that was proposed, and that DSS legal advice was to the effect that was inconsistent with legislation, was apt to mislead Cabinet, wasn't it?
I don't accept that from my perspective. That was not my intent. That was not part of a conversation around intentionally misleading Cabinet. Not
whether it was your intent or not, it was apt to do that, wasn't it?
I don't accept that, Mr. Scott. That seems an extreme interpretation. I accept that for some reason it wasn't included within this version of the submission. But I don't accept that there was intentionally trying to deceive Cabinet. That was simply not my intent and not part of any conversation I was part of.
Capping off this line of questioning, we also saw the return of Mark Withnell. So basically, you had Jason Ryman, who reported to Scott Britton, who reported to Mark Withnell. And this witness was a very senior person, heavily involved with Robodebt. His last appearance was covered in the Week 3 video, and if you haven't seen that, I recommend you watch it, because he was acting as if he knew nothing, and the Commission was calling him out big time. This time, he was saying that after he saw criticisms of the proposal, he convinced Melissa Golightly to remove income averaging from the process.
I don't have a specific recollection, but I do know that I spent some time talking with Ms Golightly to convince her that the use of income averaging would not be supported by DSS, and that it was probably inappropriate to continue with that. She was very keen on the measure still proceeding, and so I provided her an alternative, which was that we don't use income averaging for the purposes of raising a debt.
What was to happen to the recipients that did not respond?
That would then go through, my recollection was that it would go through a number of steps, either with additional letters or there will be some mechanism which is at that point had yet to be determined. That's where the pilot program through 2015-16 was going to look at some of those issues and to determine an effective way of dealing with those sorts of circumstances.
But were you telling the DSS people essentially that there wouldn't be averaging?
I don't recall the specific discussion, but we were certainly saying that there wouldn't be the use of any averaging of the ATO data to calculate the debt.
Do you have a recollection of either giving instructions to either Mr. Britton or Mr. Ryman to change the new policy proposal consistent with the change in the nature of the proposal that you've just discussed today?
I don't recall a specific discussion, but when I went through these documents, this particular change stood out to me. because I was trying to get the sequence clear in my head from this time, and for such a significant change in the wording for the reasons I described earlier in terms of the difficulty in getting wording changed, it was clear to me that this was the point at which we moved away from the use of income averaging, as described earlier, to a different approach.
Okay. Do you accept that if it was not the case that the proposal had moved away from the use of income averaging, this amendment that we've got on the screen here and that we're discussing was apt to mislead the reader of the document?
Certainly, if there was still contemplation of using the ATO data as a basis for calculating overpayments, it would in large part be misleading, yes.
Okay.
This witness was in reality intimately involved in the development of Robodebt. The use of income averaging was an essential component of the scheme. But this witness is saying income averaging was scrapped and was never meant to be happening. He doesn't know what the alternative process was, but it wasn't averaging. And that's very convenient, but the Commission wasn't buying it.
So how is it that we're still on the same figure for savings?
Sorry, Commissioner.
You see, you'd started with a process which would involve averaging of income so that you would have a pretty automatic system.
For some, yes. Mm-hmm.
And you would recoup this money from recipients. Then you move to a process where you'll just use the information to make inquiry. How can you possibly achieve the same savings? Why have you got the same figure?
I think I agree with you. It would have been more difficult, and a far greater emphasis needed to be placed on the communication pathway and the ICT system itself and the development of those to encourage more people to go online and to make it easy for them to do so to complete the process, rather than, if you like, the raising of debt from the income averaging, which was perhaps more an enforcement approach rather than an engagement approach.
It just doesn't explain why in the NPP that figure is left unchanged.
I don't have the detail. I can't answer that specifically. If you're still going to try and address the number of recipients involved, the calculation of the debt, potential debt, would remain consistent. What the actual debt was that you recovered may be different.
It'd be very different, wouldn't it?
It could be, yes.
All right.
But here is where the witness's evidence really gets challenged. Remember, he's saying that he thought that income averaging was dropped from the scheme. When the Robodebt pilot program concluded, a document was prepared with the results.
Okay, now do you accept that is a minute to the Secretary in draft?
It is, yes.
To be sent through Melissa Golightly. I should say Melissa Golightly. So do you accept that it is a draft brief discussing the results of the pilot for what was to become the Robodebt scheme?
It's discussing the early part of the pilot, yes.
Now that says the unexpected outcome is the percentage of customers who are not contacting the department within the prescribed 21 days. At this stage, approximately 60% are not contacting. These customers have debts raised based on the matched PAYG data and are sent a debt notice. Your evidence, as I understood it just a little while ago, was, at least in February 2015, customers who did not respond to the contact from the department would not have debts calculated and raised against them based on averaging.
That was certainly my understanding of the proposal we're putting forward, yes.
Right. This says these customers, that is the 60% who are not contacting, have debts raised based on the matched PAYG data and sent a debt notice.
Yes, I can see that. That would appear to be what it's saying. I'm not sure why I didn't pick that up, to be honest.
it's manifestly contrary to the position that was put to Cabinet, isn't it, Mr Withnell?
It's inconsistent, yes, and it's inconsistent. What I had understood was the intention, and I don't have any immediate explanation for why I didn't pick that up at that time, because I'd raised that issue many times that we couldn't raise a debt based on the PAYG data, so I'm unable to explain that, I'm sorry.
Right. Mr Withnell, I suggest that if it was not absolutely clear to you by this stage, it was absolutely clear to you that the process was going to use averaging against recipients on a massive scale if they did not respond to the initial letters.
No, that's not correct.
And that if it wasn't clear to you by this stage, it was clear to you that the new policy proposal that had been put to Cabinet was apt to mislead Cabinet.
No, that's not correct.
And I suggest to you that you well knew all along that is exactly what the process was going to be.
No, that's not correct either.
And that the changes were made to the new policy proposal were made in order to get the proposal across the line, even though those changes did not in reality involve abandonment of the use of averaging to calculate and raise debts.
No, that's not correct in my view. No. It's certainly not my recollection, and it's certainly not my intent.
Except that's an email from yourself to Ms Golightly.
Yes.
And it says, with EIM, an individual is required to report their employment income fortnightly, and it is applied to the period worked. The averaging of employment income over the period worked or advised by the ATO is only used by compliance and as a last resort if other information is unavailable. For example, the customer fails to engage.
That may be one instance in which it's used, yes.
Do you accept they are your words, Mr Withnell?
I'm not sure if they're my words or whose words at this point in time. There was information flying everywhere at this point in time.
Words in an email from yourself?
Yes, but where the words came from, whether they're my words or they were words from elsewhere, I just don't know.
Do you frequently send emails containing words where you haven't satisfied yourself that those words are accurate, Mr Withnell?
At this point in time, there was a lot of information flowing in lots of different directions. As I indicated earlier, it was quite a febrile environment.
And the words in the example that you've just queried, e.g. the customer fails to engage, are referring to the circumstance where a customer does not respond to attempts to contact them and averaging is used to calculate and raise a debt against them.
That would appear to be the case in some instances, yes.
That was the process under the Robodebt scheme, as you understood it at that time and at all times, from January 2015 up to this point in time.
No, that's not the case.
Commissioner, that's the evidence of the witness.
It's pretty obvious that this witness always knew that income averaging was going to be used. The next witnesses were involved in the Amato court case, which is the case that ended Robodebt. This was a test case run by Victoria Legal Aid.
So Victoria Legal Aid is a statutory authority established by the Legal Aid Act 1978, and the organisation provides assistance and legal information to help people with their legal problems. So a broad range of legal problems, including family breakdown, child protection, family violence, criminal matters, and also a number of civil law matters, which include social security, migration, discrimination, tenancy, and mental health related legal issues.
And the large majority, I think almost 99%, according to your statement of funding for legal aid, VLA, comes from state and Commonwealth funding.
That's right.
Yes.
Victoria Legal Aid, like many of its counterparts across the country, provide legal information to the public, but they also provide specific legal advice or actual representation in court for people who have a case with merit but don't have the means. When Robodebt hit, Legal aid organisations saw a huge increase in demand, but the government provided no extra funding to account for that. Despite this, they did their best to help counter the impact of the scheme.
Initially, we were just providing people with advice and information about how to navigate the scheme, but we very quickly formed the view that the scheme was unlawful, and we determined that the best way to challenge unlawfulness would be through strategic litigation. We'd helped some clients, for example, at the Administrative Appeals Tribunal, but that didn't result in significant changes to the scheme, and we determined that the best way to challenge the lawfulness of the scheme itself would be to identify a test case that would go to the heart of lawfulness.
Ms Amato, you, as you've indicated, found out that there was a debt alleged against you after your tax return was garnished.
Yeah, that's right.
And it related to a period of time when you were engaged in study. Is that right?
Yeah, that's right.
And it was in January 2019, almost 7 years later, when you found out about the alleged debt?
Yep, that's right. I just gave Legal Aid a call just to see if they had advice on how to approach Centrelink, what to do next, really.
And you ended up engaging with a lawyer called Charlie?
Yep, that's right.
Who walked you through a process and various options that were available to you.
Yep.
One of those included whether you were willing to act in a test case. Part of the strategy which was adopted by you, undoubtedly on advice, was that you weren't seeking a review process. You were rather trying to get information about the debt and how it was calculated and what the circumstances were.
That's right. We were trying to get the documentation first before we really did anything else.
And that would have informed or ultimately led to the decision about which way you approached the resolution of the question.
Yeah, absolutely. Seeing the documents clearly, swayed me to pursuing that litigation.
How did you feel about the idea of being a test case against the Commonwealth Government?
I was very scared. Gave me a bit of anxiety. It wasn't an easy decision, but seeing the documents for myself, it seemed really obvious where the mistake had happened, and I just felt like I was in the right place to do it because it was just so obvious.
And what was obvious to you about how the debt was in error?
It was averaged over the whole year, whole financial year, that a study usually starts at the beginning of the calendar year. So I'd been working full-time for the first 6 months of that year, and then I'd stopped working full-time to study. So it was really obvious that they'd averaged out over the whole year rather than the 6 months I was actually only claiming I'll study for.
And what did you understand of your reporting obligations when you received Austudy?
I knew I had to report everything, and I reported everything to the cent.
The government lost the case and ended up agreeing that income averaging was unlawful. This ended the scheme.
Declarations were made which resolved the proceedings in your favour in substantially consistent terms with those which were sought at the start. How were you? How did that affect you at that point in time?
Oh, look, it was amazing, and it really felt good that, all of that stress and anxiety was worth it. To make a change like that, it was amazing.
And did you have a sense of the significance that that case may have for other people?
I did, just as far as putting it into it, that other people didn't have to go through any more of those debts. Like, it was, a big deal.
I think it's worth sharing some closing remarks from one of the Victoria legal aid lawyers.
It's hard to put in words, I think, the impact that the system design had on people. I can only conclude that it was toxic for people's well-being. It made them, everyone I spoke to a T, and we've heard it in all the witnesses here, were frustrated, confused, angry, absolutely disempowered and incapable of finding the information just to sit down and solve the problem and understand it. It seemed like a very patronising design for a debt-raising process. People were not given basic information, and as Ms Amato described, as soon as she saw it, she understood what was wrong with it. But we saw clients struggle time and time again to get that information, and we also saw the impact on our clients and the way it made them feel.
Ms Amato, I don't know how it feels having your name tossed around as the name of a case as if it were some sort of object, but you've certainly entered into history with that declaration, and the number of times the word Amato has featured in this commission, I don't think I could count. So congratulations on the role that you've played there.
Thank you. It's surreal, but it's amazing. Thank you.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do. Your name is Peter Hanks?
Correct.
Mr Hanks, the Commission already knows a little bit about your background, but you have set out more detail in your statement. You first graduated with a Bachelor of Laws with honours from the University of Sydney in 1964 when you were admitted to the New South Wales Bar.
Correct.
In 1965, you graduated with a Masters of Law from the University of Pennsylvania.
That's true.
And embarked upon an academic career initially.
I did.
Commencing in 1965 as a lecturer at the University of Sydney.
Correct.
Until 1969, and then as a senior lecturer at Monash University until 1989.
Yes.
And then in 1991 really commenced an active career at the Victorian Bar.
I did.
And a short time later, relatively speaking, in 1999 you were appointed Queen's Counsel.
I was.
Your areas of academic expertise involve constitutional, administrative, social security law and national security law.
That's right.
To the point where you authored a textbook used by most universities in constitutional law.
Yes, I've written quite extensively on that subject.
And your practice, does it reflect those academic areas of expertise?
My practice is essentially in public law, by which I mean administrative law and constitutional law.
I've cut that down a little, but it's pretty clear that Peter Hanks is an expert in many areas of law, including social security law. In 2017, Victoria Legal Aid approached him for some advice on robodebt. He later became involved in the test cases that brought the scheme to an end.
You later came to be involved in 2019 in two cases in the Federal Court, Masterton and Amato, and this Commission's heard from both Ms Masterton and Ms Amato.
Yes.
The idea of a challenge in the Federal Court to the legality of the debt recovery scheme, where did that originate from?
I think it might have originated with me. I think I could claim authorship of that idea.
Very early on, it was obvious to this witness that the scheme was flawed.
The program relied on data from the tax office about annual income over a full 12 months. And from that, through some magical imaginary process, there was a calculation of the individual's income in a particular fortnight. And the process was, as we discovered, to divide the annual income by the number of days in the year to give a daily income, and then to multiply that by 14.
To end up with a fortnightly rate?
Yes, a fortnightly income, assumed income, in a context where almost all of the individuals who are being supported on social security payments have casual, part-time, variable employment, and therefore significantly variable income from one fortnight to another. And of course, as we know, the income test, which determines one's entitlements under the Act, works in watertight compartments, one fortnight to another. Each fortnight is separate from the next fortnight and the last one.
In this Royal Commission, we've heard plenty of times about an administrative law conference that took place in 2017. That's the one where numerous government lawyers attended.
A little later, that is, mid-2017, you presented at the Australian Institute of Administrative Law.
I did.
National Conference in Canberra.
That's right. I was invited to give the national address.
All those attendees would have heard this witness clearly argue that Robodebt was unlawful. And it was during this presentation that he also raised that he was interested in running a test case. And speaking of those test cases, when they were launched, the government did everything it could to hinder their progress.
Progression might be a euphemism for the Masterton case. The Commonwealth was doing its best to ensure that that did not happen, that there would be no progression.
Because there was no debt upon the second recalculation?
That's right. And therefore, it was said there was no utility in proceeding with her application for a declaration that the demand made a year before was an unlawful demand.
The government stopped the first test case by zeroing the debt and then arguing that the court didn't have anything to rule on. We heard about this from one of the earlier witnesses who was involved from the department. But when the second test case was launched, a different strategy was used.
We thought when we were drawing up the documents for her case, we would include a demand that not only the creation of the debt be declared unlawful, but also a demand that the money that had been garnished be repaid to her, plus interest.
That proved to be significant.
It did. The interest, I think, was something like $94. And as far as I can tell, that's what saved that litigation from the same fate that the Commonwealth sought to inflict on the Masterton litigation. Because in August, we commenced that case in June. In August, the Commonwealth recalculated Ms. Amato's debt and came up with zero.
Even though they zeroed the debt, the Commonwealth refused to pay the interest, so the case proceeded. And the court ended up making declarations that Robodebt was unlawful.
The same day that we got the letter from the Australian government solicitor saying we will consent to the declaration sought in this matter, there was a public announcement by the Minister for Human Services saying we are abandoning the OCI system. It's gone.
And that was Minister Stuart Robert at the time.
Yes, yeah. We do understand that probably what was influential there was the advice from the Solicitor General, which I've been told carried with it the implicit threat that there might be personal liability for misfeasance in a public office. There might be. That probably got the Minister's attention.
This is the announcement he's talking about.
Well, today I'm announcing that we have finished that process and we'll be refunding $721 million to 373,000 individual Australians for 470,000 debts, noting that some Australians have a number of debts. We're doing that because the best advice we have is that raising a debt wholly or partly on the basis of ATO income average or averaged income is not sufficient under law. So therefore we will return that money and move forward with our income compliance program with further proof points to ensure it remains sufficient.
And that's the evidence from week 7, with a nice segue opportunity because in the next video, we will finally hear from Stuart Robert. Thank you for watching. These videos take a lot of work to put together. And if you feel like helping the channel grow, then please consider checking out my Patreon page. I'll put a link in the description.